That guy right there, he was fired from his job as a Florida State University administrator after 28 years without cause. But Frank Stevenson claims the school fired him because he's an alcoholic, something he claims is a handicap protected under the Americans with Disabilities Act. Joining us right now for a fair and balanced debate on this topic, we've got trial attorney Justin Leto and criminal defense attorney Rachel Kugel. Good morning to both of you.
Morning.
Good morning.
Rachel, you say that alcoholism is protected and is recognized by the American with Disabilities Act, right?
Yeah, that's right. It has been, and it should be. I mean, we certainly should give benefits to those who are willing to seek treatment, and that's what the ADA is about when it concerns alcoholism. He, of course, is going to have stuff to prove in order to meet that standard, but it absolutely has been recognized as a disability under the ADA.
Okay, so Justin, it's recognized, but at the same time, one of this fellow's fellow employees who filed a complaint against him said he was abusive and he was mean toward her and he had memory lapses. He was suffering from all those things that come with alcoholism, and that's why Florida State fired him.
Right, and in Florida, under Florida law, Florida's an at-will state, meaning you could be terminated without cause for just about any reason. I'm not saying that alcoholism is not recognized under the American with Disability Act. What I'm saying is you still have to perform the same as any other person would at your job. The allegations here are that this man was abusive, he wasn't doing his job properly, and he was having memory lapses at work. That could create a safety risk. He doesn't get special accommodations just because he's an alcoholic, and I don't see this case going anywhere with him because he just was performing lesser than everyone else on the job.
Rachel, going forward, if this guy, currently he's suing for $75,000 to get his reputation and some money back from Florida State. But going forward, if people are able to use this as a defense, they could never be fired because, you know, they could say, look, I'm an alcoholic, you can't fire me.
Right. It doesn't work like that. There's a standard that the plaintiff's going to have to meet. So it's not that alcoholism itself is a recognized thing on a list. What it is that they are entitled to prove that being an alcoholic impacts the ability to perform important daily tasks.
Well, but it sounds like, you know, if he's abusive and he's got memory lapses, it's impacting his ability to perform his job.
That's right, and he is entitled
also,
to some special treatment and some reasonable accommodations if he can show that he is in fact an alcoholic.
Justin, let me just insert, the people there at Florida State University apparently have known for years that he was an alcoholic, so they knew it.
Well, he doesn't deserve any special accommodations just because he's an alcoholic. If they know he's an alcoholic going in, they can't fire him just for that reason. But if he's doing things like abusing his coworkers or he's not performing his job up to the standard, he doesn't get special accommodations. And in this case, the allegations are that he was doing just that. In fact, when you read the complaint, he never says that they specifically discriminated against him just because he was an alcoholic. They're saying that he deserves some special higher standard of care because he's an alcoholic, and he doesn't.
Interesting stuff. We'll have to find out what the courts down in Florida do. Justin and Rachel, we thank you very much for this peppy debate early on this Tuesday morning.
Thank you.
Thanks for having us.